right, so first I want to thank the AOA and the sponsors for having me today. I really appreciate being here. And I want to thank all of you landlords for being here and for educating yourself. It's really important for all of you to be here and to continue freshening up on all of these laws and the changing laws in the state of California. Last week in open court, Judge Campos said that the laws around unlawful detainers and landlord tenant law have changed 18 times since COVID started. That is telling you why we are so busy in my office. We are constantly trying to stay apprised of these laws and make sure that we are passing on correct information to you. Luckily, things are starting to have a little bit of semblance of normalcy, so we're getting a little bit back to normal. So I do want to talk to you about what the current laws are that actually were in effect before COVID happened. So, Dante, I'll let you switch. So as Victoria said, in this presentation, I'm going to talk a little bit about AB 1482, which is the California Rent Control and Just Cause laws. City of San Diego's Tenants' Right to Know ordinance, which only applies to City of San Diego properties, what the differences are between those, and whether they apply to your property and the exemptions, and then how to handle lease extensions, changing terms of tenancy and rent increases, and then also understanding your duties to repair and maintenance. These are a lot of the hot button items I have seen over the past couple years, particularly because of COVID. Now, to get us started, my partner, Franco Simone, usually does these presentations. He always tells a joke. So he's sick, so in his honor, I will tell a joke. I just listed a maintenance-free apartment building for sale. Yes, in the past 25 years, there hasn't been any maintenance. All right. So today we're only talking about AB 1482 and the Tenants' Right to Know ordinance and whether it affects your property. I'm not going to get into termination. I know you will all have a lot of questions about that. Try to hold them. We would be here all day if we were talking about that too. So I'm going to try to limit it to whether or not these laws actually affect your properties. So AB 1482 is also known as the Tenant Protection Act of 2019. You'll hear it referred to as just cause, as rent caps, as California rent control. I will keep calling it AB 1482 because that's predominantly what I hear people calling it. This implemented a statewide rent control. So it applies to the entire state of California. A lot of our landlords did not understand that this went into effect because it happened in 2019, right before the world shut down. It is still in effect, and it is still affecting all of your properties, regardless of whether you've actually been dealing with it over the past couple of years. So this infographic basically shows you when AB 1482 goes into effect and you are subject to those just cause provisions and rent caps. If a tenancy has been established for more than 12 months, that is when AB 1482 goes into effect. Those months 1 to 11, you don't have to worry about AB 1482 except for having certain disclosures in your leases. As soon as that 12-month mark hits, that's when you are potentially subject to AB 1482 unless you qualify for an exemption. There's a small caveat to this. If you do have a tenancy where your tenants have been there for 12 months and then another tenant moves in after that 12-month mark, if all of the tenants have been there for less than 24 months, then it doesn't apply. I don't have that on this infographic because that's confusing. So this is just to show you that AB 1482 predominantly kicks in at the 12-month mark. So now I'm going to talk about some of the exemptions from these rent cap and just cause requirements. So the first exemption through third exemption don't really apply to most of your properties. And it's transient and tourist hotel occupancy, like Airbnb. Housing accommodations, nonprofits, religious facilities, extended care. So predominantly our landlords, those don't apply to you. And dorm rooms, so educational facilities. The exemptions that you need to pay attention to are 4 through 9. And these ones are the ones that probably will apply to your properties. So the first Number 4, housing accommodations where the tenant shares bathroom or kitchen facilities with the owner, and the owner has to use that property as their principal residence. It can't be a secondary home, it has to be their principal residence. You have to live there, receive mail there, in order to qualify for this exemption. Some confusion about this comes from, wait a minute, is this only talking about single family homes? No, this exemption applies to all properties. It applies to every single residential property. So for example, a landlord owns an apartment building. That apartment building, you want to live in one of the units and have a roommate. Well, if you live in that unit, you have that roommate, you share a bathroom and kitchen facility, rent caps and just cause don't apply to you. AB 1482 does not apply to you. You are exempt. Okay. Exemption 5, single family owner occupied residence. These we are talking about here are houses. And these are houses that have some form of additional unit on the property. So a house with an ADU, an accessory dwelling unit, or a junior accessory dwelling unit would qualify potentially for this exemption if the owner lives in, say, the main house or the ADU as their principal residence. So in order to qualify for this one, you can live somewhere on the property and then rent out no more than 2 other units. So you can live in the main house, you could rent out an ADU, you could rent out a junior accessory unit in order to still qualify for this exemption. Six is similar. This applies to duplexes. Why they separated this out from 5, I'm not sure, probably just to confuse everyone. But this is, a duplex is a property structure that has one single roof, owner has to live in one unit, tenant can live in the other, you are exempt from rent control. Owner has to live in the property during the entire tenancy. All right, now number 7. This one is actually the most straightforward. If you've been issued a certificate of occupancy within the last 15 years, then you're exempt from rent control. So if your property was built after 2007, you're probably exempt. Some of our clients that have extensively remodeled properties down to the studs, have potentially received new certificates of occupancy, might potentially qualify for this. But this is a very specific question. I would suggest consulting with an attorney before you apply this exemption to your property. So number 8, this is where things get hairy and it's very confusing for our clients. Number 8 exemption applies to residential property that is alienable separate from title to any other property. Now, what does that mean? It means it's a single family home, a townhouse, a condo. It has to be a single structure that is separate from title to any other structure. So we're not talking about a property with an ADU here. We are specifically talking about single family homes, townhomes, and condos. In order to qualify for this exemption, you have to meet certain criteria, and this is what has been very confusing. You can't be the owner cannot be a REIT, a real estate investment trust, a corporation, or a limited liability company where one of the members is a corporation. And the whole purpose of this is to make sure that this exemption is not applying to large investors that are picking up a bunch of homes and renting them out, essentially. The other caveat to this, and this is the one that our clients have a rough time complying with, is there has to be notice of exemption that is provided in your lease. And if it is not in your lease, you are not exempt from AB 1482. So, and we will talk further on in this presentation a little bit how you can fix that if you don't have it in your current leases. If you're using the AOA form, you definitely have it. But if you don't, then we can fix that. So again, this example is a single family home. The owner is an appropriate owner, and you've given proper notice of exemption. The notice of exemption is this language exactly. If you have not provided this language in your lease, you are not exempt from rent control. The last exemption, it really is just like Section 8, federally subsidized units, low income units. That's what all of this long language means. any property that receives some form of like low-income tax credit. Usually those types of properties are exempt from rent control because you have a whole nother federal law, state law, local law that you have to comply with that outside of AB 1482. So you are exempt from any of these requirements. All right, so really, what does all of this mean? It means you only need to qualify for one exemption. So those exemptions 1 through 9 that we just went through, a lot of our clients get confused if they don't have that notice of exemption in place, whether or not they can qualify for one of the other exemptions. If you fall within one exemption, that is all you need to exempt yourself from just cause and rent caps under AB 1482. You don't need to qualify for multiples, it's just the one. So if you're an owner that lives in your home and you rent out other rooms and you haven't given notice, it's okay because you qualify under a different exemption. So you only have that one. So again, only exemption number 8 requires that notice of exemption that we just saw. And those are single family homes, townhomes, and condos that those apply to, where the owner does not live on the property. All right. Now I'm going to talk specifically about the City of San Diego's Tenants' Right to Know ordinance. And for those of you that have been in the City of San Diego for a long time, this has been around since 2004. It's not something new, it's just confusing because now we're dealing with AB 1482 that we just heard kicks in at 12 months. And then we have the City of San Diego's Tenants' Right to Know ordinance, and this thing kicks in at 2 years. So up until the 12-month mark, we're free from rent control. The 12-month mark hits, we have AB 1482, and then at the 2-year mark, we have to deal with the Tenants' Right to Know ordinance. I don't know how landlords are supposed to keep all of this straight. So this is a lovely infographic, again, where it shows us, okay, here is where Tenants' Right to Know kicks in. What the Tenants' Right to Know ordinance does is it creates different just cause termination requirements than what is required under California rent control. And again, we will talk about what all those requirements are in the next seminar, but we just need to make you aware that the laws apply differently depending on how long the tenancy is and whether or not that AB 1482 applies, or if you're kicked into Tenants' Right to Know and you're having to terminate under these laws. So just like AB 1482, there are certain exemptions for Tenants' Right to Know ordinance. The main exemptions that landlords will qualify for are agency-owned or subsidized units, they're the top 2, or room rented to boarders. What this means is the exemption for, say, Section 8 tenants. Those are the agency-owned or subsidized units. So Section 8 tenants, properties that receive that IRC Section 42 low-income tax credit, those are the type of units that would qualify under that exemption. Rooms rented to boarders if the owner lives in the property and rents rooms out. Those are similar to the exemptions that we had under AB 1482. But as you can see, we only have 2 exemptions here that probably apply to your properties, whereas AB 1482 has many more exemptions. It is much harder to get around San Diego Tenants' Right to Know ordinance. So if your tenants have been in a property for 2 years or more, this applies. And then in order to terminate, you have to comply with just cause, meaning you cannot just terminate the tenancy for any reason. And again, we have a whole seminar that will definitely fill up 2 hours on termination and what those causes are, but I just need to make you aware that these are the laws that are in place that affect your properties. A quick caveat, currently, and this is the only COVID law that I'm going to talk about, we do have the City of San Diego's no-fault moratorium, and it is currently in place right now. It is from May 22nd to September 30th. What this law did is it stopped every single no-fault termination in the City of San Diego. So if a lease expired, so what no fault means is the tenant didn't do anything wrong. If a lease expired, you cannot kick your tenant out. If you want to give a regular 60-day notice to quit because the tenant hasn't been there for an extended period of time, you cannot give any form of notice without cause. You cannot give a notice and that an owner is going to move in unless you give a 90-day. It basically threw every single law and every single rule that you know about in the city of San Diego out the window. If you have a property in the city of San Diego, I strongly advise that you contact an attorney before you take any action against your tenants, because there are penalties associated with these laws. So what I just touched on, you can terminate for at fault. So the tenant's being a nuisance, the tenant has subletters, the tenant's not paying your rent, you can still terminate for those reasons, but you cannot terminate for any no fault cause, the lease expirations, those kinds of things. There are 3 limited exceptions: that 90-day notice for an owner relative to move in, a government or court order, or the unit is in such bad shape that it is affecting health and safety, or a 6-month notice of withdrawal from the rental unit or from the rental market. Obviously, this law expires at the end of September. I would not advise to serve that notice now because you would be waiting 6 months after the moratorium ended. All right, so quick recap. So at the 12-month mark, we have AB 1482, which is the California rent control that creates just cause and rent caps. So just cause meaning you can't terminate your tenant for no reason. You have to have a reason to terminate them. And rent caps meaning you cannot charge a rent increase above a certain amount. So that's what happens at year 1 of the tenancy. Year 2 of the tenancy, if you are in the city of San Diego only, then the city of San Diego's tenants' right to know ordinance kicks in, and you have to deal with just cause for those tenancies, solely for just cause, not for the rent caps. The rent caps are still theoretically handled by AB 1482, and there is some confusion about this, even amongst attorneys, on what laws supersede other laws, but tenants' right to know ordinance definitely takes hold of the just cause requirements of the 2-year mark, at the 2-year mark. All right, that was a lot of information. We are going to shift gears a little bit. So I will do one more joke just to keep things flowing. What did the yoga instructor say before she was evicted? Namaste? Was it good? Franco didn't like it. I ran it by him, he didn't like it. Okay, so now I'm going to talk about maintaining the tenancy, and what are the differences between the rights and the duties of the landlord. I cannot say more about the importance of having a good contract in place that has terms in it that I can enforce. The AOA has a very good contract that gives me terms that I know and I'm able to actually enforce against tenants. The worst conversation that I have with a client is when they call me, they start telling me that, their tenant is a total nuisance and they keep causing problems and, they're having parties and they're doing all these things. And I say, okay, send me a copy of your contract. Oh, I don't have a contract, it's an oral agreement. Okay, so at that point, we have to figure out avenues to get these people out, right? Because if I don't have something to look to that tells me what those rights and obligations are of the landlord and the tenant, it makes it very difficult for me to do my job. You essentially pull my teeth out. I have no teeth at that point. I'm not able to do anything within reason. And we'll talk about how we can fix some of these problems. So in the following slides, I'm going to tell you about how to change the terms of your tenancy in order to fix that issue, the terms to include that the AOA already includes in their leases, and then common issues that are arising during tenancy, particularly since COVID has occurred and the issues that we are dealing with in my office right now. So in order to change the terms of your tenancy, it depends on whether you are in a lease or in a month-to-month. If you are in a lease, you can only change the terms of your tenancy if your tenant signs an addendum. They have to be willing to sign on to those new terms, or else you do not have any binding agreement. We have a lot of clients that give, new house rules to tenants. Potentially you can incorporate those into the lease, but you have to have a contract that says you are allowed to do that. So generally speaking, if you're in a lease, you cannot change the terms until that lease expires or is about to expire. On the other hand, month-to-month tenants, you can change the terms of that tenancy without the tenant actually signing anything by serving a 30-day notice and change in terms of tenancy. And you would serve that notice like you would any other 3-day pay rent or quit by either personal service, substitute service, give it to somebody at the property and then mailing it, or posting and mailing. And at that 30-day mark, those terms become incorporated in the lease. And the tenant can't say, I didn't sign it, it's not effective. That's not how it works. It's the tenant is served that notice. If they don't like those new terms, they can move out. They can turn around, serve you with a 30-day notice that they're vacating. If they do not do that, those terms become effective and they become part of your contract. The reason that's important is what I was just talking about. If you give me a contract that has no teeth in it, if I serve one of these notices and change in terms of tenancy and create new terms for this tenant, then I can go potentially serve notice against that tenant to terminate them for the nuisance issues, for the partying, for all the things that they're doing that we created terms for with that notice. All right, so I just want to talk a little bit about when leases expire because this becomes confusing for some of our clients. Expired residential leases, even if the terms say that they automatically terminate, if you accept rent past the termination date, you automatically accepted that tenant month to month. So you automatically continued that tenancy under the terms of that expired lease. That lease is no longer expired. You allowed it to continue month to month. That's a little bit of a hard differentiation for a lot of our clients, so I just want to make that clear. I also want to talk about the benefits a little bit of a lease or a month-to-month agreement. Right now, when the vacancy rate is so low, I absolutely recommend only having month-to-month agreements. And also, because, like you heard, the laws have changed surrounding tenancies over 18 times since COVID happened. If you are in a lease, I can't change the terms of your tenancy to fix issues that you have in a lease if the tenant is not friendly and won't sign off on those changes. So it is very important that you look at your contracts, and if you're able to, potentially use a month-to-month agreement. When things are a little more unstable, tenancies aren't staying in place, and you want the benefit of knowing that you have a lease agreement at a certain amount of rent for a year, then I understand having those leases in place. But right now, considering the current climate, I strongly recommend using those month-to-month agreements for your tenancies. If you say, no, I absolutely want leases in place, I have a higher income unit. So a lot of times this happens when the rent is $6,000, $7,000 a month and you have tenants paying up front. And you'd rather enter into lease extensions. That's fine. But that is the opportunity that you have at that lease extension time to incorporate additional terms into your contracts. Make sure you have the appropriate disclosures, talk to AOA, see if there's new forms out that are required, because if you lock yourself into another lease extension, that's your shot to fix up your contract. And if you don't do it when you go to renew that lease, and then you come to me saying, hey, I have all these problems, I'm gonna tell you, sorry, you got yourself into this lease extension, you're locked in again. One more thing, and a lot of our clients have issues with, is that they have leases that can renew at higher amounts. They say, well, I'll let these tenants stay if they pay a much higher amount in rent, because that's what I could get if someone else moved in. I want them to pay fair market. The rent caps in AB 1482 apply to lease extensions. So you have to comply with those rent caps when doing those extensions. And I'll talk about what those numbers are in a couple slides, but I just want to touch base on that right now. All right, so rent increases. This has changed a little bit. The time frame for certain notices has been extended. So the amount of notice that you need to provide your tenants for a rent increase depends on the amount of the increase. So for anything that is under 10%, which is actually going to be everything in the state of California right now, and I'll explain to you why that is in a second, it is a 30-day notice. And you're going to serve that notice like you normally would serve a notice. If you do end up serving it by mail, you need to give an additional 5 days. So just make sure that you're giving yourself enough time. I always suggest don't give that notice of rent increase at that 30-day mark. Do it a little early, just so your tenant knows it's coming. So then that way you're not blowing deadlines on when it becomes effective. Just make your life a little easier, right? If it's more than 10%, then you have to give a 90-day notice. This used to be 60 days. It's since been extended to 90 for the past few years. 90-day notice to increase that rent more than 10% is only allowable if your property is exempt from AB 1482, so you don't have to comply with the rent cap, and we're not in a state of emergency. So currently, we are, again, in a state of emergency. Yesterday, I think another state of emergency was announced for monkeypox, so it seems like this is never going to end. But Penal Code 396 does not allow you to increase rent more than 10% during a state of emergency that applies to either your state, your city, your locality. You have to look in multiple places, and a lot of landlords don't know about this law, and I know we touched about it in the last presentation, but this is important. There are a couple exceptions, and the first one is if the increase is directly attributable to additional costs for repairs or additions beyond normal maintenance, but this has to be amortized over the rental term, and you have to be able to prove that this increase was because of that. I don't necessarily know what all this means. I don't think I've ever seen it litigated. Your guess is as good as mine. I mean, I could tell you what I think it probably means. If you did a full renovation, you're doing more than just cosmetic things. I think you probably will fall within the exemption, but I don't know. The other caveat to this is that it also applies for new tenancies. So if you say do a renovation, you don't fall within this exemption, you're still stuck at that 10% cap. So it's just something to think about. I think a lot of our clients are violating this right now. I don't think anybody is really cluing into this, but this is always in effect, and it's always been in effect even before COVID, because we've been advising clients on this even when fires happen. So when fires are happening, you can't start jacking up rent in order to force tenants out, because it's anti-price gouging is essentially what this law is. The other exception is if the increase was already contractually agreed to by the tenant. So say you have automatic bumps in your lease, then you would be able to implement that increase that's higher than 10%. But this has to have been done prior to the state of emergency being enacted. So the COVID states of emergency have been going on forever. I don't know a lot of residential landlords that have rent bumps in their contracts that are currently going into effect. So I doubt that would apply to most properties. All right, so if you are not exempt from rent control, so you don't fall within one of those 1 through 9 exemptions, the tenants have been there for more than 12 months, that means that you are subject to the rent caps of AB 1482. What this means is that you cannot raise the rent during any calendar year more than 5% plus the CPI. So from August 2021 to July 2022, that was 5% plus 4.1% to give you that 9.1%. And you find these in the Consumer Price Index. They are a little difficult to find. My suggestion would be call the AOA, call my office. There's a lot of infographics that are being floated around that you can find to find these numbers, but just make sure that you know what they are, because it changes depending on the time frame and changes yearly. So any increase that was effective, again, August 2021 to July 2022, 9.1%. August 2022 to July 2023, it is 10% because it's 5% plus that 7.9% was the CPI, but we know it can never go above 10% because of AB 1482. These are, again, going to be posted on our website, and anybody can pull them from the link. But I'll give you, I see a lot of pens writing, so I'll give you a second to write down the numbers if you need them. So
two increases per calendar year?
That's what I was going to get to. Try to hold your questions just so I can get through all of it, and I will do a pretty extensive Q&A for those of you that want to stick around. So you're correct. It's 2 increases per calendar year. So, and it's not 2 increases of 9.1. It's a increase total of 9.1 or 10%. So if you wanted to do 2 5% increases, you could do that in a calendar year, but it cannot exceed what the cap is during that calendar year. All right. Okay, so we just talked about how we can change some of the terms in the tenancy using that notice of change in terms of tenancy. That includes the rent increase. That is a change in terms of tenancy that landlords are familiar with. Here are some other terms that are very important that I see missing from a lot of contracts. If you are using the AOA form, you should have these types of terms in your contracts. If you are not, first, you should talk to the AOA and get their forms. Or try to do a notice and change in terms of tenancy to implement some of these changes. The first would be that notice of exemption. If you don't have it in your lease, you need to incorporate that. Make sure that you have a security deposit provision in there. If you did not ask for a security deposit up front, you can always implement a security deposit and collect that from the tenant. It can only be 2 times the rent if it's unfurnished, 3 times the rent if it's furnished, but it's important to have a security deposit on these properties. The next thing, a capped attorney's fees provision. What this means is that there's a clause that says if you go into litigation, the prevailing party can receive attorney's fees and costs up to a certain amount. That certain amount I suggest is less than $500, $1,000 at the most. The AOA has this in their contract, and the reason for this is, and this is very important, is that there are tenant attorneys that drive up litigation costs in the hope that there is some form of technicality that you're going to lose your case on. And if you lose, the landlord, as the landlord, you will be paying the tenant's attorney's fees. So you will be paying all of the attorney's fees to that attorney. If you win and you get your attorney's fees, that's great, but you probably won't be able to collect against that tenant anyway. So it's really doing you no benefit to have these clauses besides drawing in an unscrupulous tenant's attorney that is going to drive up your legal fees. As soon as I see an uncapped attorney's fees clause, meaning a clause that says the prevailing party gets all their attorney's fees and costs, the first thing I tell that client is, I probably am not going to move forward with litigation unless we get rid of that term. Because I know that this is going to cause problems for you, and it's going to be far more expensive for you than waiting 30 days for that change in terms of tenancy to go into effect. All right, another important term, and this is particularly because of COVID, is relocation for repairs. We've had tenancies that lasted a lot longer than they probably would have because of COVID. The turnover didn't happen as much. There has been a lot of clients that have these tenants that are hunkering down because even though the COVID fog is lifting, tenants still think they don't have to move. They don't have to get out of properties. There's still protections, even if that's not necessarily the case. If you don't have anything in your contract about relocating for repairs, it makes it very difficult for me to require a tenant to temporarily move out. A lot of contracts either have a, tenant has to temporarily relocate if I give you a 7-day notice. So that's an example of a type of provision that would be in a contract. Or for any work that requires, more than 2 days, you can get temporary relocation. But it's important that these clauses are in there because if the contract is silent it is very hard for me to force a tenant to move out with actually serving them a notice to comply with maintenance and then filing an unlawful detainer, an eviction. And currently, evictions are taking like 90 to 120 days. In the good old days, it was 30 days to 60 days. Now it's 90 to 120 days, depending on whether or not we can actually get the sheriff's department out there to lock these tenants out. So again, very important to have some avenue for tenants to move out of the property if you need to do extensive repairs. And it could be plumbing, it could be, termite tenting, it could be, any form of like bathroom remodel, any type of extended repairs. Next term, insurance. It's important to have an insurance clause in there. A lot of tenants don't realize that your insurance does not cover their personal property. So having it in there, or at least having a disclosure to them that your insurance does not cover their personal property, that you either recommend or require it, is preferable. Non-curable subletting and assigning. So this one is we often use to try to get tenants out if we're able to prove it. If it is non-curable, I can give a 3-day notice to quit versus a perform covenant or quit. And so it makes the process happen faster. The tenants can't say, oh, we complied, they moved out, and then move them back in a week later. It just allows me to terminate immediately with a 3-day notice to quit for subletting and move forward with an eviction. So that type of clause helps me. It gives me my teeth back, lets me move forward with actually enforcing these leases. And finally, late fees capped at 6%. I see a lot of late fee clauses that are higher than 6%, or they are a per diem. They're a 6% plus $10 for every day that the tenant is late. So it could be a $500 late fee clause on a $1,000 rent. That's illegal. Higher than 6% is considered usurious. And a lot of clients ask, where did this law come from? It comes from case law. It's actually about mortgages and another line of case law, but it has been applied to late fees and penalties. So late fees, penalties, they can't go more than 6%. Okay, so we just talked a little bit about some of the terms that you should include. These are some of the terms that you cannot change or you cannot enforce. Every single contract, whether it's oral, written with a tenant, has implied warranties. One's the implied warranty of habitability and the implied covenant of quiet enjoyment. Most landlords know that you have to provide a habitable unit. And this is in case law. You have to provide heating, you have to provide proper weatherproofing, you have to provide tenants this habitable unit no matter what your contract says, no matter whether or not the tenant has agreed to do repairs, it does not go away. And it is against public policy for the tenant to waive these provisions. So you can never require a tenant to do major repairs. And I don't recommend that you have a tenant do any repairs. I recommend you have them do no repairs, just because that is when there often becomes problems with the tenant saying that they did XYZ repair in order to pay for rent. Well, then the numbers don't match up and we are not able to get tenants out because we don't actually know what the rent is that is owed and the repairs were probably never done. So then you don't have an actual habitable unit. Implied covenant of quiet enjoyment, it just means that the tenant is able to live in their unit peacefully. Good example is a landlord just showing up constantly. It's the first time they rented their house, they still see it as their home, so they keep stopping by in order to just, check on the house, check on the plants, make sure things look good. You can't do that. That's interfering with the implied covenant of quiet enjoyment. Again, this applies to every single contract, regardless of whether it's in your lease, and a tenant can't waive it. So illegal terms, these are different. These are just terms that are unenforceable. So some of those terms that we talked about, that illegal late fee provision, rent increases that are too high. These are just illegal terms that I can't enforce as the attorney. So if I see these in your contracts, usually you have a severability clause that allows me to still enforce other parts of the contract, but I can't enforce those illegal provisions. And say you have an illegal late fee clause in there, you've been charging too much for your late fee, well then that means you've accepted too much money from the tenant, you've accepted more rent from the tenant than you think you've accepted from the tenant, and then it causes problems for me when I go to serve that 3-day pay rent or quit, and then I look at your ledger and I see, oh, what about all these illegal late fees here? We need to take all of those out, credit the tenant back that money, and then we can potentially move forward with a 3-day pay rent or quit. So again, I just can't enforce those terms. So it creates some problems when it comes to enforcement for me on actually requiring the tenants to do what they should be doing. Another thing, we touched on this a little bit, that the tenant cannot be responsible for major repairs. You, again, are required as the landlord to provide a habitable unit. You cannot require a tenant to make major repairs. Having a tenant switch out light bulbs, that's probably fine. Having them maybe even switch out smoke detectors, maybe fine. But just do the repairs. If the tenant even causes the issue, do the repairs and charge the tenant for it. So we just talked about the applied warranty of habitability. That's from case law. This is a California statute that governs habitability, and some of these items you are going to think are silly. But this list is statutorily based. If you do not provide this to your tenants, your unit could potentially be seen as uninhabitable, meaning that you cannot charge the amount of rent that you've been charging. The tenant is entitled to probably some form of reduction. And I don't know how much that reduction is going to be. Only a judge is going to tell us that, but we know that you cannot charge the full amount of rent. And if I go to serve the tenant with a 3-day pay rent or quit, we go to trial, a judge might find, no, the tenant's been paying too much rent because of these issues. So big ones, effective waterproofing, hot and cold water supply. Heat is a big ticket item. You say, it's the middle of summer, it's 90 degrees out. Why do I need to get the heater fixed? Because it's a habitability issue. It is a statutorily codified habitability issue. You have to fix a heater. You have to provide a working and operable heater for tenants. And I know that seems silly being in San Diego, but that is the California law. All right. The other one that a lot of our clients think is silly, a locking mail receptacle for each unit. This is particularly important because if we go to start serving notices to tenants and they are not able to collect their mail, they're not receiving proper notice, so they don't have due process. They have to be able to collect those notices and actually receive those notices. So that's why this is important. I'm not going to read this list. It is a list of all of the reasons that you can post a 24-hour notice to enter. And if you thoroughly read it, you will see that it's not to do a general inspection. So we just talked about the habitability issues. A lot of clients are like, all right, great. I'm going to do a general inspection every single year to make sure there's no habitability issues. Well, that is not a reason on this list. And this list comes directly from a statute. And you can get this form from the AOA, you can get this form from my office. We have a specific form that gives you the reasons. Luckily, testing smoke detectors is on that list now. So that is a little bit of a loophole that legislature gave us a bit of a bone where we can actually go in for a reason that we didn't have before. But if it doesn't fall within one of these reasons, you cannot enter the property unless the tenant agrees to allowing you to enter. So that's just something to think about when you're thinking about doing these repairs. All right. So now we're moving into the duty to repair. So where we started at this was when we are maintaining the tenancy, we have to have our good rental agreement in place, right? So first we start with our good AOA contract that actually has the rights and obligations in the contract of what you're required to do. Hopefully, you have a contract in place that tells you what your duties are. But what I tell the client, the first thing I need before we talk about repairs is I need to see a copy of your lease. I need to see a copy of your rental agreement. So I know what type of notice the tenant is supposed to be giving you for these repairs and whether or not you are complying with your lease as the landlord. So, regardless of whether these provisions are in the lease, the tenant does have to give you notice of needed repairs. If you don't know about the repairs, you have no duty to repair. You have no obligation to start making repairs that you have no idea even exist. Additionally, landlord is not responsible for things that are caused by the tenants, their guests, their pets, their licensees. But to go back to what I was talking about before about not allowing the tenant to make repairs. Even if the tenant causes these problems, the tenant's dog rips up the flooring. I had a client recently where the tenant broke out all of the windows of their house twice and removed the front door.
Wow.
What was my advice to the landlord? Replace the windows. You have to make the unit habitable. And then charge the tenant or take the money from the deposit and require the tenant to replenish the deposit. Do not allow the tenant to start making repairs themselves. And obviously, we filed an eviction at the same time. So we got this tenant off the property. But these are things that happen. You have to fix these issues, but you can charge the tenant for those repairs. All right, so we got our notice from the tenant saying, hey landlord, I'm having plumbing problems, the toilet needs to be fixed. After you receive that notice, what do? You go investigate immediately. Depending on what the issue is, obviously some things are more urgent than others. Tenant saying, my toilet's not working, it's backing up, and I have no other bathroom in the house. Well, that requires a landlord to move a little faster than saying, hey, the light in this room isn't working. After landlord receives notice, you investigate, and then you have a reasonable amount of time in order to make that repair. This standard is an objectively reasonable amount of time. So from an objective person, how long you would have to actually make that repair. Certain repairs might take 30 days, and that's okay, because that is a reasonable amount of time for that particular repair. A repair on a toilet that's backing up, well, that's probably a same-day repair. That would be the reasonable amount of time in order to provide your tenant with working plumbing. So it just depends on what the repairs are and how quickly you need to actually have those repairs made. Again, look back at your lease or rental agreement to see what you're required to do, because that is what governs your tenancy. And I know that a lot of times these contracts are long and they have a lot of legalese in them. If you don't understand what your obligations are, please either call the AOA or my office so that we can try to help you. Because it is important as the landlord that you are also complying with the lease to make sure that you are protecting yourself. Because down the road, when you come to me and you say, hey, the tenant is suing me because they have mold in the property, and when I ask you, well, did you have notice of it? And you tell me, no, I had no idea there was mold, but they told me that there was a leak 8 months ago, and I just ignored it. I thought it was gone. And when I asked, so you did no other investigation? Did you send a plumber? Did you send, did you go over there? Did you feel the wall? Well, no, the tenant didn't complain about it again, so I thought it was fine. Well, now you're telling me that you probably already had notice that there was a problem and you didn't fix it. And so then that creates problems on my side, especially when I take a look at your lease and see that the tenant did everything that they were supposed to do and you did not do what you were supposed to do. So it goes both ways. All right, so finally, landlord's duty to relocate. This is, again, like I said before, has been a major hot button issue in my office. I've had a lot of cases where we have been issuing notices to tenants to relocate, trying to get tenants to relocate when the lease is silent and it says nothing, because the state of California has not given us a lot of guidance on how to handle these issues. There's no set amount of money that a landlord is supposed to be providing a tenant to relocate unless you fall within AB 1482 for when tenants are moving out. But if it's for repairs, there's really no guidance here. So that's why we need a lease or a rental agreement that has very specific provisions that tell you what to do. And usually it's a per diem. So, and that's my hope when I see a contract, is I hope that when I have a client that comes to me and says, I have a tenant that I need to relocate because the shower is leaking and and it needs to be fully removed. So I need to relocate them while these repairs are being made. And I say, great, let me see your contract. If there's a per diem in there that says, hey tenant, if you are required to relocate, all you receive is a per diem of the rent. So take the rent, divide it by 30, for however many days the tenant is out, that is what the tenant is supposed to receive for relocation. My general advice to clients is to offer that to the tenant. If they get some form of pushback, maybe sweeten the pot a little bit for the tenant, just to say, hey, we booked you this hotel room. It might be a little more than the per diem, just in order for you to get those repairs done. But again, this is kind of a gray area because there's not a lot of guidance in California law that tells us what to do here. So if you have those provisions in your lease that really tells you what to do, outlines for the tenant what happens, that is very helpful for me and will be helpful for you and the tenant because everyone knows what their rights and obligations are at that point.
May I ask you a question? The question,
Yes.
for the
He's clairvoyant.
relocate to the landlord. I have,
Is whether or not you have to provide a food credit for the tenant, pay for their food
the food, yeah, and the hotel.
and the hotel. So if you are moving tenants into a facility that they don't have a proper kitchen, they don't have food, a lot of times I tell my clients, throw the tenant $20 towards food a day. Because ultimately, it might keep the tenant happy. It's going to keep a lawyer out of the situation. So you're not going to have a tenant attorney that is going to probably look at your contract and see that uncapped attorney's fees provision, and the tenant's going to lawyer up. So I say provide them like $20 a day for a food credit if you can. It's a very case-by-case scenario though, and it depends on what the repairs are, and it depends on what type of unit you're moving the tenant into. We have a lot of clients that move a tenant into a vacant unit. There's a stove in there, there's a fridge in there. They can move their stuff into there, they have a place to cook. If they're in a hotel room, they don't have a place to cook and they're having to eat out, there's an argument on behalf of the tenant that you should provide them some form of food credit. Does that answer your question? Yeah. Go
I
ahead.
had a question about a property sub 1482 potentially. Say you've got a single family home.
Okay.
It's the CO was issued more than 15 years ago, so it's older. You don't owner occupy, it's investment property. It has an attached garage, which you then convert to an ADU.
Mm.
The ADU, of course, the CO is in, not subject to 1482. Have you just made the main house subject to 1482?
Okay, so his question is, was there an actual certificate of occupancy issued on the ADU?
Yes. So
There is.
So the ADU, I'm presuming, is exempt. It's got a new CO.
Okay, so the question is, there is a single-family home that has an attached garage. The single-family home is older than 15 years, so the certificate of occupancy was issued more than 15 years ago. The garage was recently converted to an ADU with permits, received a certificate of occupancy. Whether or not that garage is exempt,
And both are not owner occupied, both are investment properties.
and both are investment properties and are not owner-occupied.
I've heard some say yes, some say no, so I forgot to ask.
I think yes. And
So yes, you just made the house up at 1482.
no, only the garage would be, yeah, the house would be subject to AB 1482 and the garage would not. And the only reason, so the actual statute says housing that has been issued a certificate of occupancy within the previous 15 years. It's housing. It's not telling us it has to be a single family house, it has to be alienable and separate, it's only saying housing. So when we read statutes, we have to key on that specific language. So I'm of the opinion that that would be fine.
So you basically are saying the main house would now be subject to 1482 or not?
The main house is subject to I would think that the main house,
So building ADU, you built yourself in the 1482.
I think so. I think you just built yourself a little exemption there. Whether or not a judge is gonna buy it, maybe not. But I don't know. That's
Well,
a,
I'm saying by building it, you basically made your main house subject to 1482, where it wasn't before, because it was the same family residence. That was what I was saying.
oh, yes.
Yeah, okay.
Yes, correct. So that's your other caveat. Yeah. Okay, we'll go right here.
So I have a similar question about you. So you said Section 8. Is that a Section 8 tenant who is in an apartment building, a house? Are they exempt just for that unit? Or it has to be an entire affordable housing project that is a housing commission ownership?
That's a good question. So the question is whether or not, if you have a Section 8 tenant and you fall under the exemption with that Section 8 tenancy, does it matter what type of property that tenant lives in? And my response is no. If that tenancy is not subject to AB 1482 because they have to, well, it's not subject to AB 1482 just cause. It potentially is subject, well, no, it's not subject to AB 1482 period. Because it also falls under the, there's a little bit of differences between the just cause and the rent cap exemptions. I don't want to get into that, it's far too confusing. But the rent cap, you would be exempt under both.
So even if the property is not exempt, but you have a Section 8 tenant in there?
That tenancy is exempt.
And my next question is on affordable housing. It's not Section 42 property, but they do fall under the low income category, not the low, and they do welfare exemptions. How would that fall?
Ooh, I look at each of the programs. Yeah, I look at every single program. I do this with a lot of our clients. I actually have to pull the program, because usually there's covenants or CC&Rs on these properties. I have to actually look at what programs they fall within. And the caveat is it says, or other similar program in the law. So again, we're doing our best here to try to figure out what these mean.
Thank you.
We'll go over here.
I have a question about AB 1482, and basically what it is that the addendum that you guys have on your website, 202E for the addendum.
Are you talking about the AOA's addendum?
Yes.
Okay, so,
And I have that form there, plus the other form that AOA gives for the explanation,
okay,
which I gave to both the tenants that we had.
okay.
And one renter signed it, the other one didn't.
Okay.
What do I do then? Because most of the addendums you guys have in these forms here don't require a tenant signature. This one does.
Is the tenant not being friendly? They won't sign it?
Not quite yet, just served the update, so I'm hoping that they sign it, but if they don't, what are my alternatives?
Are you in a lease or are you in a rental agreement?
Always rental, never.
Rental agreement, okay. So in this situation, if the tenant, obviously, easiest way would be for you to get that addendum signed, right? Because then it becomes incorporated into your contract.
Right.
If the tenant refuses to sign, since you are in a month-to-month agreement, you can serve that 30-day notice and change in terms of tenancy that we talked about during the presentation that would incorporate that notice into your lease. So essentially it would become a part of your lease without requiring signature of the tenant. You cannot just serve that notice on the tenants for that to become effective. So it is a separate type of notice that tells the tenant, hey tenant, within 30 days notice of service of this notice, these terms are going to become effective as part of your lease. So it doesn't work by just serving that. It is a separate form that would use those terms in it. Does that make sense?
Only if they decide not to sign it.
Correct.
Okay, so if they do sign it, then I'm exempt from it on the one property. On the other properties, they don't sign it. Then I have to change the lease to change the rental agreement to where this is typed in the lease.
Correct. It can be a separate addendum as long as they sign
The
it.
same format.
But yeah, it can be separate, but the tenants have to sign it. If they don't sign it, then
It's not effective.
correct. You can't just serve that notice on them.
Okay, thank you.
You're welcome. Go ahead.
In addition to that question, I was told that if we did not serve the tenant like in 2020, regardless of what we are doing right now, we are not exempt, even if we are. If we did not serve it in 2020.
So I didn't want to get into these laws because they are confusing. And it's going to make everybody's head spin if I start going backwards. I'm trying to look forward and out of COVID. But what you're referring to is when AB 1482 went into effect in 2019, it gave landlords a certain amount of time to serve the notice. And if they didn't serve the notice by that time, then you weren't exempt. And then properties after a certain amount of time just had to have the notice of exemption in their leases. They could no longer serve the notice. If you didn't do that prior, we can fix that, because we can fix it with that 30-day notice and change in terms of tenancy, because then the term becomes part of your lease and it's okay. Those landlords before, if they complied, they could just serve the notice. So they could take the notice that the gentleman over here had and just serve it on the tenant.
Right.
But that was old.
Yeah.
Yeah.
The reason I'm asking because I was in this exactly the same situation.
Okay.
And this is what happened. I was told that I cannot fix it, and I'm grateful that we can with terms, change of terms. But what happened, I did make a mistake because doesn't matter, but I thought I have to notify them that I'm exempt at the time if they request that. And I did, and they said, no, we're not signing anything, we don't want, and you will pay us money dearly.
Well, and the beauty of that is that you can give them this notice, the 30-day change in terms of tenancy, and they don't have to sign it. You serve it on them, it becomes effective in 30 days. If they don't like it, they can move out.
Yeah, but I have to create this form, AOA form, change of terms.
Correct.
Not just serve them.
Correct.
Serve them, but it's not that.
You have to serve them with the proper notice, not just with that notice of exemption. So it has specific language in it that tells the tenant that it will become part of the lease.
Okay, so when he said that I rescinded everything before, and I said that I will pay you last month's rent. I give you 60-day notice. Just get out because I have to move in, and it's emergency. But he said, no, I want 2 months rent, and I will not pay you a penny, and this is what I was advised. So for the month of July, he missed the rent, he did not pay. I said that I will reimburse him or give the relocation for the last month, August, for the free rent, okay? So he did not pay the rent in July. My question is, does this automatically transfer him from no fault move out to at fault move out because he did not pay rent?
Well, I would have to make sure that you have a lot going on here, probably more than what we can cover right now in this Q&A. And I think that we probably need to have a conversation because this is probably outside of the scope of the Q&A. But generally speaking, if you serve that 30-day notice and change in terms of tenancy, you can exempt yourself. Currently, you are subject to AB 1482, so you have to comply. So the rent caps, the just cause, if you're not complying with those, then the tenant potentially is correct.
Yeah, but does he?
I think we need to wrap this one up. I'm sorry. I understand that you have a lot of questions there, but without seeing your documents, I cannot give you sound advice. Yeah. Is it a follow-up to what you had?
Kind of, yeah. Basically, for
I'll let you go, and then I'm going to come back over here.
okay, basically what's happening here is that years ago, when the apartment buildings we used to have, I would serve a change of terms with just a simple letter that basically changed, like for example, the grace period from 5 days to 3 days or something like that. Nowadays, do we have to use the AOA change of terms?
If you're just sending a letter to the tenants, it's not going to become part of their contract. So this is in order to make it part of their contract. It is literally this notice that we are serving on you incorporates these terms into your lease. So
every time we have to change anything in the rental agreement, we have to issue that form plus the.
I suggest doing that. Unless your tenants just agree to an addendum. You don't have to deal with any of that if your tenants will just sign an addendum. If you're moving the rent due date for the tenant because they're saying, hey, our social security comes on the 15th, I can't pay you rent on the 1st, you say, okay, tenant, let's sign an addendum. I'll agree to that. Let's sign an addendum moving your rental due date. Okay, we'll go back here.
Just to make sure I understand on the maximum rent increase.
Mm-hmm.
So it's either 9.1 based on recent or 10% max. That's the first question. And then, but if they're a Section 8 tenant, is there a different number?
So Section 8 tenancies, you're dealing with Section 8 there, right? So you're not dealing with AB 1482. So that's out of that realm.
So the 10% and CPI plus 5% don't apply?
Correct.
Okay.
Again, I showed you all that penal code section 396. There is potentially a 10% cap in the state of California anytime that a state of emergency is enacted. And it can not just be California, it could be city of San Diego or just a particular area that your property is located in. There can be different states of emergency enacted that kick in those anti-price gouging laws that cap your rent at 10%. Okay, we'll go right here.
With respect to the habitability rules, lockable mailbox apply to single family residence.
That's what the statute says. I would just buy one on Amazon. Get them something that locks. Give them a key. Yeah. Whether or not it's going to actually reduce the amount of rent that you're collecting, probably not. And usually this isn't going to be a problem unless there's litigation, right? So we have the legal aspect of it, and then there's a whole practical aspect of it. Obviously, I'm giving you the laws for what the laws are. From a practical aspect of it, if you have a regular mailbox, your tenants aren't complaining, do you really think you have a problem? Probably not. But from a legal aspect, I'm going to tell you you do. Okay, back there.
Okay, the covenant for quiet enjoyment.
Mm-hmm.
Okay, I live in a neighborhood where I'm basically surrounded by vacation rentals.
Okay.
Inform the new tenant that the location and proximity to the vacation rentals. And then I put an addendum in my lease. I guess I should have announced it, not too late for that because it starts yesterday. So I have an addendum in my lease that the tenant must observe, adhere to, whatever, comply with the San Diego City Noise Abatement Code.
Mm-hmm.
And I have a copy of the code with the decimal rates and everything else. But then what happens when the tenant comes to me and says, hey, sorry, the rental noise is just too much. I've got to break the lease and move out.
This is some gray area, right? Because what level, I don't know what is actually going on with these Airbnbs. I mean, if it is constant and it is, just so interfering with the tenant's tenancy that they can't even live there anymore because they have music playing until midnight every single night, they can't sleep, and they can show that, this is happening. Potentially they could try to break their lease, but that's that's all about termination, what we're gonna do next time. But it could give rise to the level of an issue with quiet enjoyment. I would just say just work with the tenants and try to figure something out.
Okay, then another quick question. Where do you draw the line between normal wear and tear and tenant care?
That's a loaded question too. Burns in carpet, things that, holes in walls, those types of things are obviously not normal wear and tear. If your carpet's 7 years old and your carpet had a 7-year life expectancy and you're like, these tenants thrashed it, well, your carpet didn't have a life expectancy past that anyway, that might not be seen as, even though it wasn't normal wear and tear, may or may not be okay. Obviously a lot of it's a judgment call, but that's why and this is outside of what we've been talking about, but do a move-in checklist, do a pre-move out inspection, and then obviously when the tenants move out, do that move-out inspection. Give them the opportunity to fix it. Unfortunately, our small claims court in San Diego is very, very, very tenant-friendly. So the more documentation that you have, the better off you're going to be with those types of issues. All right, we'll go back there.
I just have a question on habitability. I mean, we have our part, but I did a smoke detection inspection last week on my tenant.
Mm-hmm.
And from last year to this year, they're like, she's a total hoarder. I mean, there's stuff everywhere. So it's like, oh my God, but I know that hoarding could be a mental illness issue. And so there's that, you don't want to discriminate against that. But then there also has to be something where it's a health and safety issue, and also, the pathway should be clear for windows and doorways. What happens in that case?
So that is classic nuisance. We file a lot of cases based on issues like that, mainly because one, it's a fire hazard,
Right.
Particularly if this is happening in an apartment building.
Well, the duplex.
Yeah, so you're putting the other tenants at risk. I would say, because it could be a potential fire hazard. My assumption would be that they're probably blocking vents, they're probably blocking electrical, there's probably things up against electrical that shouldn't be. These types of issues, those are very evictable issues, and they're very easy to prove because you can give me pictures.
Well, are you allowed to take pictures?
Yeah,
I didn't take pictures.
you can testify.
Allowed.
If the tenant lets you, take some pictures. But you can testify to it. You can just say that there's stacks all the way up to the ceiling. I've had clients that couldn't get into units in order to see what was going on, but they took pictures from the exterior and you could see that the windows were blocked with personal property. So that was enough.
Windows being blocked would be enough, like furniture up against the window.
Absolutely, that's a fire hazard. If there's a fire, they're not gonna be able to get out of the property. They can't be blocking windows for ingress and egress. So that's an absolutely affectable issue. You're welcome. Right here.
Yes, a month-to-month tenant that's long-term tenancy and the rental agreement is totally out of date. I've been told like we can ask them to sign a new rental agreement, but they don't have to agree to sign it.
Yeah, in that type of situation, what I would, especially when it's a long-term tenant, and they've gotten to the point usually where they feel like that is their home, it's their home, they have a sense of ownership. I would suggest approaching them to just try to get them to sign new agreements. If that doesn't work, then serve them with a notice and change of terms of tenancy to incorporate all those new documents, but that can be really confusing. So I would suggest just try to get them to sign a new contract with the disclosures, and you could do it with a cover letter and also in person. A cover letter basically saying, hey, we're trying to implement new contracts just to make sure that everything's up to date so that everybody understands what's going on. Give me a list of repairs if you have any repairs that you need because you've been such a long-term tenant. A lot of times, I don't know if there's carpet. If the carpet's over X amount of years, you probably need to deal with that. Those issues you kind of need to massage a little bit to try to work that out. Right here.
Yeah.
Yeah, go ahead.
Yeah, this question also pertains to habitability. Normally, landlord's responsible for pest control. What about this scenario? So the landlord obtains, say, a service contract with Truly Nolan for the entire property. The landlord then bills back to the tenants proportionally, like a RUB system, almost like utility, their portions of that contract. So that way, there's a pest issue, the tenant just contacts Truly Nolan directly to take care of it. What do you think of that?
You're just giving me all sorts of things to think about right now. Yeah.
I've already done it, so that's good.
Yeah, I assumed you had. My only hesitation on it is that, you as the landlord, you have the obligation to provide habitable premises, meaning that you have to provide a unit that is free of pests, that has heat, all of those things. So that's my only hesitation. There's a lot of things that we can contract around, but not habitability, right? If the tenants are griping about it, I tend to think you can't do it. Yeah, I don't think you should be doing it. In a house, absolutely. Require the tenant to have their own pest control, right here.
Late fees capped at 6%. The 6% is based on the monthly rent.
Correct.
Okay, quick question. One of my units, 200 square foot studio. Do I have to have a wall heater or will portable little heaters be applicable?
I think you need a wall heater. Usually we'll say that, yeah, electric. I think you need a wall heater. Portable heaters we tell our clients to use in the case of where the heat's gone out, you're waiting on repairs. But I don't know of anything that allows you to not have permitted heating. Right here.
Last couple of years I started when like a house I'd rent and had a refrigerator, I'd put in the lease that we're not replacing it, we're not fixing it, get your own. Kind of get out of the plants rental business. I just want to rent the place.
Mm-hmm.
So recently I have another house I rent and it has a solar power system. And it's an older one, so I'm thinking maybe I should be putting that in my lease too, that we're not going to repair that, because that could really add up to a substantial or significant repair cost that the owner may or may not want to repair at that juncture of the rent. So would you think that I could write that in the lease saying that we're not gonna repair it, even though the tenant knows living there, they're gonna save a lot of money if that solar power is working?
Yes, I say that that is something that you should have in your lease. Yeah. We'll go with someone that has it in the back.
You mentioned about the hoarder taking pictures of the wind from the outside.
Mhm.
That's not considered invasion of privacy?
There's no expectation of privacy from the exterior of the building. So if you're not, as long as you're not, going up to the window and peeking in
Right.
and doing one of those things, don't do that. But if you're, you could be on the street and be able to take a photo from the exterior usually.
If the curtains are open, then they,
Take a picture. There's no expectation of privacy.
yeah.
Yeah. Right here, since you haven't asked.
Okay, so my tenants signed the lease contract first year, second year, month to month, and they're going to the third year.
Okay.
And they don't want to sign any contract, at least they want to do month to month, so that won't be any problem. So just wondering, that's normal?
I would prefer contracts to be month to month, just because it makes it easier for me to enforce your agreements. Yeah, especially with the vacancy rate so low, because you'll be able to find new tenants. I know turnover can be a pain, but I would prefer to have month-to-month agreements in place.
Okay, thanks.
All right, Victoria?
Thank you, Laura. A question about documentation. You mentioned on the small claims court that more documentation is useful. What is considered documentation? Emails, texts, or is it only letters, mail, things like that?
So small claims court, I kind of call the wild, wild west of court because there's no real rules of evidence. The rules that I have to comply with, you do not. So you can pretty much use anything, but you don't want to confuse the judge and you don't want to annoy the judge. So if you have proper documentation, proper forms, like a move-in, move-out sheet where it shows when the tenant moved in, they had brand new carpet, they had new paint, they said that everything was in working order, then you do a pre-move-out inspection if the tenant asks for it. And you give the tenants an opportunity to fix those items, and they didn't fix say, the carpets are very dirty, the unit overall is very dirty, and in the pre-move-in inspection, it was clean. Those are kinds of documentation that help. It's things that you can look at the timeline and say, okay, here it was clean, here it's dirty, tenants didn't fix it, this is a proper deduction. Those are the most important type things. But text messages, emails, all those things can be used as well. You just need to make sure that you're organized and that you're only, in small claims particularly, say it's a security deposit issue, you're only talking about the security deposit issue. You're not talking about all the other things that the tenant did wrong the entire time they were there that irritates the judge.
Thank you.
Right here.
If the tenant didn't request a move-out inspection after some paperwork after they moved out, then you want a sheet about when they moved out, you might have to send them my move-out inspection form, the last one.
So you're asking if you have to send them your move-out inspection form?
The last one. The final one.
And they didn't give you a pre-move-out inspection?
They did not want to, they did not request.
They told you they didn't request one?
Yeah, they didn't file back the paperwork, but they were asking for it now after they moved out.
So I'm assuming there's a security deposit dispute? Is there a dispute? Did you?
No, not yet, I'm just asking you. Because I have to do that, not do the pre-move-out inspection.
I don't know the answer to that question. I don't know whether or not you have to give that to them. I'm not sure. Yeah, sorry. All right, we'll go, you haven't asked a question.
Is San Diego in a state of emergency right now?
That's a good question. I looked yesterday and it didn't look like we were, but then there was a state of emergency issued for monkeypox that I haven't read yet. So I don't know. I am going to try to ask my staff actually to send out an update on what states of emergency are actually in effect right now, because that's been a question that I've been asked a couple times, and I haven't actually read what the state of emergency reads yet, so I don't know what it applies to. So it depends on what the order is.
Just a real quick one, have you heard of triple net being able to be used on residential properties?
So what his question is whether a triple net can be used on residential properties. So that would be requiring tenants to pay for, you're not gonna be able to, no, you can't do triple net, to answer your question. But on commercial, you absolutely can. So what triple net means is requiring the tenant to pay for taxes, insurance, and repairs, usually to common areas. But that's a commercial term.
I'm not doing it, I just knew of another lady that had tenants, and she said, she did it, I thought,
Yeah, tell her to knock it off.
yeah, we had commercial property.
And some insurance you could pass on. Insurance and some taxes you could, but you can't pass on repairs. Yeah. Right here.
So back to attorney fee caps, does it, at some point, does the quality of the tenant alter your opinion on that?
Absolutely.
So if you're renting to a CEO, you don't really need a cap, that might want not to have cap.
It depends. It depends on what type of property you're renting. Obviously, that question comes with so many different hypotheticals, right? We're still just talking about general landlord-tenant law, right? So what you would be suing each other for is for breach of contract of a lease, and whether or not, that would be fully litigated for a residential unit. Commercial is a totally different world. But for residential units, I couldn't see litigation being that extreme with, like, say, a CEO, right? Where you would need a cap or where you would need like an unlimited attorney's fees provision. Because usually you're just suing each other for breach of contract, which would either be, for habitability issues. The higher attorney's fees we see is for like mold cases, personal injury cases. So I don't know, that tenant slips and falls, you have a personal injury case, and all of a sudden you have attorneys going after you for that personal injury, you don't have a cap on it. They could potentially go after you for those fees.
The purpose of the cap is to flip the economies of scale so that the landlord is not becoming an insurance company, right?
Correct.
So if you have a cap, that can work against you because that tenant to say, well, I can let you into the ground.
Yeah, but for what purpose? That's
Just be nasty.
Yeah, I still recommend having a cap on it. And if you want to raise it for a particular tenant, raise it. But I still suggest having a cap on it. Right there.
I have a question about renter's insurance. I know in California you're allowed to require it, and it's in the AOA rental agreement. If you send out a request to tenants asking them to send you their renter's insurance, and they either decline and say, no, I'm not going to get it, or just don't say anything, just don't respond at all, should you push back on that, and how much should you kind of enforce that?
So what I would suggest in that situation is like start sending the tenant like a letter, and if they still don't do it, then potentially serve a 3-day perform covenant or quit, requiring them to provide you with that information. If you come to me with that 3-day and tell me to file an eviction on it, I'm going to tell you that I can't, because it's not material. And a judge is not going to terminate a tenancy and give you back the property just based on insurance. If it's insurance coupled with other things that could be considered a material breach, then I would say, yeah, let's just include it, and just so that we can show the tenant's doing a bunch of bad behavior and just being generally non-compliant. But for the most part, you can't actually really enforce it.
Can I get a hint on that?
Uh-huh.
It's kind of make it like a security deposit for the first month's rent, you have to see it before they actually move in. And you make yourself insured.
That's correct, but if you have tenants that have been in there for more than a year and requiring them to pull it afterwards, then we have problems. Yeah.
So you cannot require it?
You can require it, but it would be considered a breach of contract for them not to have it. But the eviction courts, the UD courts, have seen it in case law as not being material. So it's not a material breach that would allow you to actually terminate the tenancy and get an eviction. Back there, because I haven't heard from you yet.
Can you explain the difference in termination of tenancy? Like, for example, when you have a lease, a 6 month or 1 year, when it terminates, you don't have to give them a notice, yet you can proceed with eviction because they stay over. But then there was certain one that you have to give them 30 days or 60 days before you can start with an eviction.
so what's the?
Right, so this is what our next AOA presentation is going to be on, and I could talk all day about termination and different ways to terminate. You're generally correct that tenancies that have been under a year, you can just serve a regular 30-day notice to quit, assuming that you're doing what you're supposed to be doing. Tenancies over a year, there's your 60 days, assuming there's no rent control and assuming you're not in the city of San Diego. There is a lot going on right now as far as termination goes. Any city of San Diego property, I would say, contact an attorney before you try to issue any form of notice. But generally speaking, you're right, you can issue a 30-day or a regular 60-day under the normal laws, assuming that you don't have to deal with AB 1482, you don't have to deal with tenants' rights to know ordinance, or the San Diego eviction moratorium. Right? Makes your head spin. Okay, go ahead.
All right, question is, I do know that my tenants have somebody else, like subletting for money or what have you. What is acceptable proof for that, from my part? I know that, and I want to send him, you know.
You can testify, but it would be better if you had other people that were able to testify, neighbors, other people around to testify about it. You know, if you've seen them at the property constantly, their car is constantly at the property, that's all testimony that I can take. But you have to have people that are willing to testify to that.
So should I pick perform a wait or something like this? Just
I have to see your contracts.
Okay.
You and I just need to talk.
And then yeah, and then as to the change of terms, do we send for every change of term? Do we send a separate change of term, or we just list it?
That's a good question. You can list all of them together. So it's a 30-day notice and change in terms of tenancy, and usually we just label them either 1 through 10, A through Z. Just give them some form of lettering system so that we can refer to them, or numbering system. But you can list all the different terms that are changing in that one document.
But basically, in 30 days, it becomes part of the contract.
Correct.
Here you don't end the story.
Correct. We're gonna go right here.
So if you're trying to, if somebody's not paying their rent, and hasn't paid their rent, and you serve them a 3-day notice, after that, do you have to go through eviction court, and go to taking small claims? If you take them small claims, will that get them out of the unit?
No, small claims will not remove your tenants. You have to actually file an eviction, and they're taking about 90 to 120 days, and you cannot accept rent during that eviction term. All right. We'll take like 1 or 2 more questions, and then I'll let everybody go who wants to go, and anybody that has more specific questions that they want to talk to me about, I'll hang around.
You speak about non-curable subletting, the signing clause. Does the AOA or the car form have that, or is that something special we have to do?
Does the AOA have a non-curable subletting clause in it? I believe it is.
I think yes, I think it's in there. It's in there.
In the lease, I'd have to look at that.
I think it's in there.
I think the AOA does have it in there. Yeah.
Do you know on the car form?
I don't have it with me, in front of me.
I'm just saying, I would want to deal with that. Do they have it?
I'm sorry, I can't hear you. The car form has it.
Oh, okay.
Yeah,
That's what I use.
yeah, the car form has it. The AOA form, I believe, has it too.
Okay, great. Thank